Good morning, everyone. Good morning. Good morning, everyone. We're going to start so we can stay on schedule, okay? So first of all, thank you for coming to our meeting. We're going to get some great information today that we need on a daily basis, which is all about tenants and all that stuff. So I'm super excited that you're here so you can learn. So before we start, I want to introduce Rebecca, who is our sponsor for today for our lunch. Rebecca, take it away.
Thank you, guys. Oh, thank you. I don't know how to curtsy. That was the weirdest thing ever. Okay, good morning, you guys. I am Rebecca with First American Home Warranty. I'm so excited to see you guys. And yes, so First American, I want to let you know, has a specific product for you guys that's called Crest. I have had some questions lately. Please remember when you order your home warranty that it must say Crest, C-R-E-S. And the benefit for the homeowners, they get 13 months of coverage. The seller gets protection for up to 180 days, and they can purchase an additional 180 days of coverage for $100. And it just protects them for liability for any lawsuits, things like that. If you've ordered Crest, you guys are covered. When you write it in the RPA, you have to say Crest because another agent could be from a different office, and if they order without it, you're not covered. When you have Crest as the agent, if there's any lawsuits or any issues, half of your deductible for your lawyer is covered. So if you pay $10,000, we cover as Crest covers $5,000. If it's $5,000, we cover $2,500. So it's such a benefit. We have to make sure it's on there. Once it's out and rolling, there's no way to change it. So it's not your TC's responsibility, even though I'm an extra pair of eyes, my assistant's an extra pair of eyes, so is your TC. You always at the end have to make sure that we have the right product for you guys, okay? So please, when you order it, make sure that it's First American and it says Crest. And I hope you guys enjoyed just my little, I always like to leave little goodies to say hello and how much I value and appreciate you guys. It's always a small token, but to me it means so much. So thank you guys for working with me, I appreciate it. Please enjoy your lunch. There's Cokes, Diet Cokes, and Sprites in the bucket. So make sure you get a beverage. Other than that, have a great day. Yeah.
Thank you, Rebecca. That's awesome. Okay, so the next thing we're going to talk about real quick, it's a little commercial, is family reunion. Now, who's thinking of going to family reunion in this room? Woo! Woo-hoo! Okay, awesome. So how do we get the rest of you to go?
Guilt trip.
Yes, because it's an experience that really shows you what Keller Williams does for their agents. Our company is based on our agents. What do they need? How do we get them to be successful in business? So that's where you see the big picture of Keller Williams. And so it is $1,200 to go. But we're offering a savings plan if you want to save, like when you do a closing, we separate 100, or if you just want to send our Venmo account $100 a month until that date. So really think about it, really try to go. It's an amazing experience. I've gone to, I don't know, I've been with KW 11 years. I think I've gone to 6. And every time I go, I learned something new. It's super valuable, and it just makes me, love KW even more. So I really want to encourage you guys, if you have any questions on family reunion, call me up, okay? Any questions? Okay.
Speaking of family reunion real quick, I have some stats I'm going to share at the next team meeting with you, just to give you an idea numbers-wise, I'm a big numbers person, of the difference of agents that do and don't attend events like this, and how it builds up your business. Huge networking opportunity. We have home court advantage because it's in Anaheim. They don't have to book flights, right? You don't necessarily have to book hotels unless you want to go in on those after party things. But I may or may not know some inside information because Mark King will probably be here the week before family reunion, and there might be an opportunity for agents to meet with him personally because we are technically the host area for family reunion. So you do have to be at family reunion to be able to attend that event. Just a heads up. Y'all know who Mark King is, right? No? So he is the president of the company.
And he's
Kind of a big deal.
and we
Head
could
honcho.
talk to him, is that correct?
That's like your foot in the door to the next step to having a one-on-one with Gary.
That's amazing. And we're planning on having a happy hour one of the days of one of the meetings. So stay tuned. We'll let you know when, where, all that stuff. Okay? Okay. Anything
And
else?
remember, for family reunion, even if you do the after party, we have Uber. And Uber is not that expensive to get from Anaheim to Whittier, so
That's true.
there's no reason you can't go.
Oh, like.
Okay, I have a couple things I want to share with you guys before we have our speaker. These are some things that we have coming up. So every Friday at 1 o'clock, Denny Grimes, and I don't know if some of you have been in KW for a while, you would know Denny Grimes is married to Kristen Cole. Kristen Cole has a humongous company that she's built, and her husband runs their team and does a ton of business. So every Friday at 1 o'clock Eastern, it's 10 a.m. our time, he is talking about, with our new market, how we can overcome the most common objections and the best words and strategies to use, asking the right questions, learning what to say and when to say it, learn the answers and scripts for the sellers who are interviewing other agents, drive the sellers to the fair market price, which is super important right now, and answering buyer remorse questions. So this is going out in an email today. You can either come to the Market Center, because we will have it playing here, or you can register on your own, and you would be able to do it at home, because it is a webinar. The other thing I want to share with you guys, who knows what 72 sold is? Okay, that's not good. Okay, so 72 sold is a program that KW is doing, and they have partnered with a company in Arizona, 72 sold, right? And they have systems and models in place where their agents are doing a ton of business. And I've seen the stats. We've talked to agents that are in the program, that are here in California doing the business, and they are succeeding at a very high level. There is a $199 one-time fee to join, and then it's $72 a month, which is what Gary negotiated with them, because normally it's almost $500. When I told Bobby Johnson about this, because she was paying the $500, she was like, what? So she's excited because it really worked for her. She was getting a ton of listings by using this program. If you want to know more about it, there's 2 more webinars that they're going to do that's going to share what 72 sold is, how it will benefit you as an agent, and then you can decide whether you want to sign up or not. Here's the caveat. I signed up as a Market Center, and there is a thing that they're doing that's new that will start in January, and that's national advertising. They're going to be running TV ads, and what they're finding is that they can guarantee 4 to 6 listings, 4 to 6 listings for every seat that you buy. A seat is $1,500 a month. It's expensive, but if you're getting 4 to 6 listings, it's well worth it, right? What I did is signed up as a Market Center. I bought 2 seats. So that means we'll have those coming in. I can only give those referrals to the agents that are signed up with 72 sold. That's the agreement we have with 72 sold. So if you're not part of the program, those leads cannot go to you. So if you want to do that, you need to go check this webinar out, see what it's about, and then if you like it, sign up. $199 one-time fee, and then it's $72 a month.
I have something
Sure.
to say about that. So I'm a member of 72 Sold. I have a listing. I followed their program. I had 6 offers on that listing, and we accepted an offer 50,000 over asking. So it's working great.
Oh, awesome.
So, well, and to kind of go off of that, I was at the stockholders meeting in Fort Worth a week ago, I guess. I don't even know what
That's
day
Friday.
today is, so whatever it was. And they had 2 OPs that run teams. They have a team of, I think it's like 4, and one had a team of 3, something like that. They'd only been a part of this program for 30 days. They've already taken 4 listings just by following the process. So it is a very regimented system, and it gives you everything that you need to do. But if you follow it, it works. I mean, we've talked to a ton of agents about this, and it does work for them. So please, please, if you are interested in making more money, who is? Everybody's hand should be up, right?
Yes,
Okay. Let me see. I just had a couple more real quick things.
While you're pulling that up, so 72 sold, by the way. I chatted with their team yesterday. If you sign up now, you don't have to start paying the 72 a month until January. So you do the intro fee $199. I signed up yesterday. The intro fee of $199, and then starting January 1 is when they start the $72 a month billing. And there is no contract. There's no obligation. You can do a month and say this isn't for me, and you're done. You could keep it as long as you'd like to. It's an at-will start-stop.
And they'll go over that in the webinar, but one of the things that you do have to do is there's about 12 videos that you're gonna watch. And then to become certified, as a certified agent to be able to receive the referrals, there will be a test that they're going to send out after you've watched the videos, and I believe that's gonna be available in November, late November, for you to take that little quiz. It's not a big deal, and it's just based on the videos that you guys are watching. Okay, last thing I wanted to do is Monday, November 7th, Martha, Ruben, myself, Gina, and our new ALC group will not be in the office. Maddie's going to be here by herself, so be kind, okay? But I just wanted to share with you who's joining us this year for ALC, and that's Andrea Beggs. Antoinette, yeah. Marlo, who is not able to be here today. Nick Mattis, Rose Flores, and Wayne Tellez. So that will be the ALC, as long as they all agree to it after our ALC meeting. We might scare them, we don't know. But that's who your ALC for next year will be. So we're super excited about that. It's a whole, pretty much new group. Rose was with us this year, but we have some great things we want to plan, and we really want them to be your representative, to hear you and what it is that you want, so that we can make the changes that we need to do to survive and thrive in the market that we've got coming. So that's it for me, you guys. You want to?
Yes. Okay, so here we go. So I'm introducing Eric Francisconi, who's the speaker for today. He is a partner of Schulman and Bastian Friedman. Oh my God, that's hard to say. Focusing his practice on complex business and commercial litigation, real estate litigation, and probate litigation. He is also a licensed real estate broker with the California Department of Real Estate. In his over 27 years of practice, most of his cases pertain to contracts, trade secrets, unfair competition, fraud, fiduciary duties, real estate property estates, employment, commercial landlord rights, the rights and responsibilities of participants in corporations, LLCs, and partnership. Eric has extensive experience as a successful first chair trial attorney in jury and non-jury trials throughout California. Eric's peers have admitted him to the American Board of Trial Advocates, the country's premier organization, experienced civil trial lawyers and judges. He graduated cum laude from the honors program at Loyola Marymount University with a Bachelor's of Arts degree, and from Loyola Law School, where he was an articles editor for the Loyola of Los Angeles Law Review. Lots of experience, right? So I'm super excited. Eric, you're on.
Good morning, everyone. It's great to see you. Martha, thank you for having me. Veronica, thank you for putting this together. It's wonderful to see you. So what I'd like to do is I have a little presentation, and then I was told, well, we have more time than that. So what we're going to do is I have another topic I'm going to throw in at the end, and then I'm going to have some time to be able to field some questions. But why don't we go ahead and jump in. So first thing we're going to do, we want to talk about the current eviction statutes. As you know, there have been restrictions on what you can do during the COVID pandemic. So we're going to talk about where things lay with that right now. California Tenant Protection Act, AB 1482. And if you work with any landlords, or you are yourself a landlord, you know that that's something that is difficult to navigate and difficult to understand, but we're going to talk a little bit about it today. And then I'm going to throw in something before that, if we have time, on partition actions. And that is if you have two property owners and they can't decide what to do with the property. So what happens? And we're going to talk about court action that can come out of that and how those cases might get resolved. So if that issue ever comes up with you. First, we're going to talk about eviction statutes and ordinances. And the big word is everything was delayed for a long time, for a number of reasons. First, we had federal law that came in. So in March 2020, Congress passed the Coronavirus Aid, Relief, and Economic Security Act. It was just for 120 days and just limited to certain federal properties. Then the CDC came in September of 2020 and instituted eviction bans until August 26, 2021, because they said, why is the Centers for Disease Control able to able to govern landlord-tenant law? So the Supreme Court struck that down. So right, there are no federal bans, but there was a lot of things going on in the state. Excuse me. So first we had in March 16, so that's right around, everything came down, March 16, March 17, 2020, if you remember. Governor Newsom imposed the executive order, but it was limited to non-payment of rent because of COVID-19. So it was still kind of limited. But for all intents and purposes, he kind of didn't really have to do much of anything because the courts closed down. And so you can't have an unlawful detainer case. So let me back up a little bit in case you're not familiar with it. If you are a landlord, you cannot just kick somebody out. You have to go get a court order. And the way you get a court order is to file a case in the Superior Court called an unlawful detainer case, where you then get an order for unlawful detainer saying you are detaining the property, you should not be there, you should be kicked out. And then they have the sheriff basically do the lockout. So what was happening is that the courts were closing, so you couldn't file anything. Even when the courts opened, for a while, they weren't going to issue a summons. So what happens with that? You file a complaint to start an unlawful detainer case, but you have to serve it, right? The court would not issue you a summons to be able to serve it. So couldn't really do anything with it. And then, even when the court started getting back up and running, the trials were getting pushed back. And then the really smart tenant attorneys were saying, yeah, you know what, and we're going to invoke our right to a jury trial. And there were no juries. So everything just got pushed way back. And that's without any kind of formal regulations. Excuse me. Now, in September 4 of 2020, there were some specific things that came out. That was the COVID-19 Tenant Relief Act. Then January 28 of 2021, COVID-19 Relief Act there, which surprisingly did actually have some protections for landlords, understanding that a lot of landlords aren't necessarily large companies, but a lot of people, this is their sole investment, perhaps owning one property and then being able to hand it out. So then if your tenant quits paying you and you're still responsible for mortgage or the upkeep and that kind of thing, it becomes a real hardship. So the protections that were in place ended up being very specific as to timing. I'm going to do this quickly because we're kind of past it. So you had certain things that were available from March 1st, 2020 to August 31st, 2020. And then you had to basically, it's all different levels of distress for what you needed to be able to do. And as time went along, thank you very much. As time went along, things got a little bit less restrictive as far as what landlords could require and what tenants could do. And then they had to submit applications in order to participate in the program. But now, so at this point, if you didn't submit an application as of October 1st, 2021, you're not in the program. So there was an extension, however, that pushed it out to March 31st of 2022. With the extension, having some certain limits, and the extension itself then eventually ended in June of this past year. So that program really isn't something that's going to protect tenants anymore. Is there anything left? Now that here we are, we're all meeting in a group, we're here in a room together, we're not wearing masks, and people are basically kind of going back around their lives. So what's still left? Local ordinances are still left. Because when Governor Newsom issued that order back on March 16 of 2020, basically said, I'm going to do this, but if cities want to do something more restrictive, they can. And so over 150 municipalities, those are states, those are counties, those are, like I was explaining to Antoinette earlier, that you could have two different apartment buildings, one right next to another, one in the city of Whittier, and the next one in unincorporated LA County, unincorporated Whittier. Different rules entirely as to what you can do. Those rules still exist in at least about 40 different municipalities. So what you have to do is you got to know where you are, and you've got to have somebody look up as to whether there's something specific that that municipality does in order to protect tenants' rights. So it's complicated. The takeaway from all of it is that except for local ordinances and pending applications, there are no currently COVID-based restrictions on evictions, and the court delays are improving. Now that's a big except though. The local ordinances and any applications that still haven't been processed, but those local ordinances are the ones that really will trip you up. So you need to make sure if you are working, if you're a landlord or working with a landlord, make sure to have them consult with legal counsel or a very experienced property manager who knows the restrictions, because you don't want to get into a situation where it's an unlawful attempt to evict someone. And we're going to talk a little bit more about that in a minute. But court delays are improving. Things were very slow. Even when courts came back, they came back very slowly for all cases. And it's still taking a lot longer. I'd say before the pandemic, in a regular civil case, not an unlawful detainer, regular civil case would take about a year to get into trial. Some courts longer, some were shorter, but about a year. At the beginning of the pandemic, it became like 2.5 to get a trial date. So it's, but things are, as we get further and further away from the shutdown, things are getting a little bit better. Let's shift gears for a moment over to the California Tenant Protection Act of 2019. This is that AB 1482 that I was telling you about. This is a couple of statutes in particular in the Civil Code that took effect in January of 2020, so before the pandemic. And they're going to be around until 2030. So what this does is limits rental increases and limits evictions. There has to be some kind of notice in the lease as to that these statutes apply, so that this is available to the tenants and they know that it's there. Excuse me. Now, even for the 1482, it is possible again for the courts or for local ordinances, local cities and counties, to do something even more restrictive than what we're going to talk about. So again, it matters where the property is as to what you can do. Now, what does it apply to? It applies to all residential properties with certain exceptions. If it's constructed within the last 15 years, it doesn't apply. Now that is, that's a rolling thing, because at some point it's not going to be 15 years anymore. Once it gets past the 15-year point, then it's under these restrictions. Unless there's some kind of deed or something that it's limited to affordable moderate incomes, the Section 8 housing, for example. A 2-unit property, if there's an ADU or something in the back, then that doesn't necessarily apply. Single-family homes and condos are exempt if they're not owned by a real estate trust corporation or LLC. That is, so if you own a house and you're renting it out, that kind of thing, unless you are a real estate trust corporation LLC, you're not covered by it, or the landlord notified the tenant. So if you're doing this, the lease really has to cover the fact that they are not protected by AB 1482. So what does AB 1482 do? Well, it deals with rental increases, it deals with evictions. First, as to rental increases. Annual rental increases are no more than 5% plus the percentage change in the cost of living for the region where the property is located, or 10%, whichever is lower. Let's assume, with inflation being what it is, it's 10%. So that's as high as you can raise the rent in 1 year for any property that is covered by AB 1482, which you saw before is almost everything. No more than 2 increases in a 12-month period, so you can increase it 5 and 5, 7 and 3, you just never can get higher than the 10%. Then there is no limit on the initial charge for a vacant unit. So if a tenant leaves, you can set the initial rent for whatever you want. You're just limited on how much you can increase it as it goes along. Now, Second part is the eviction protections. Now, if the tenants have lived in that unit for 12 months or more, or one tenant has occupied the unit for 24 months or more, then there are restrictions as to what you can do. And now, for the first time when this passed, you have to show just cause as to why you are evicting someone. Just cause reasons are categorized. Now, so that's the one thing you have to show. And then there's no fault just cause, and then there's fault just cause, at fault. You've got to give notices, and you've got to give opportunities to cure. So generally, you'd have to give a notice of breach under the lease anyway, but here you have to give a notice as well for anything that would be at fault. And we're going to go over that list in a moment. So, relocation assistance is required for no fault. This is why it matters. So if somebody is at fault, if you're the landlord and you can get them evicted, you don't have to do anything for them. If, however, you can show that there is some kind of so if there's some kind of fault, then that's great. But if it's no fault, you either got to waive the last month's rent or payment in an amount equal to that, and then you've got to pay it within 15 days. And there's also there's rental assistance. You have to help somebody find a new place. So that's why a lot of landlords are anxious to prove that if they're evicting someone, it's for a good reason, or that specifically that they're at fault. What makes you at fault? Failure to pay rent. Breach of a material lease term. What is a material lease term? That's going to be up to a court at some point. Is it important? I mean, it's like, okay, well, they, aren't mowing the lawn. They put their trash can in the wrong place. Probably not going to work. However, if there's something, that they're, obviously failure to pay rent or something else, that's a different story. Committing or permitting a nuisance, committing waste, so they're damaging the property. And again, waste, it has to be, ties back into material. It's like, well, I don't think they, wiped out the dishwasher. Not going to work. Something more than that? Possibly. A written lease that terminates. And they refuse to sign an extension on similar terms. So, normally, and this is a misconception, that people think, well, if a lease is over, then they have to go. I don't have any responsibilities as a landlord. Not true anymore in California. You do not have an automatic right to kick someone out of a property, kick a tenant out, simply because the lease has expired. You have to have a reason why you're not extending the lease. It falls back on the landlord. We live in California. There are a lot of tenant protections, and that's a big one. Subletting. So what if they have criminal activity? If there's been something that they've done, that's an at-fault reason. If they've subletted without approval, refusing to allow the landlord to enter the unit, using the premises for an unlawful purpose, kind of goes back to the criminal activity a little bit. An employee, agent, or licensee fails to vacate after termination, or failure to vacate after the tenant says that they're going to vacate, that they're going to surrender the property. So that means that that's at fault just cause. No fault. If you have a landlord that says, look, I still want to do an eviction here, but I don't have a good at fault reason. So these are the no fault reasons where somebody can kick somebody out. Owner wants to move back in, or have kids move back in, or parents, or whatever. If you're going to be able to withdraw the residential real property from the market, I'm no longer going to use this as a rental property. You have to comply with the government order if there's some kind of taking going on from the government, for example. Or an intent to demolish or substantially remodel residential real property. You want to just tear it down and do something entirely new. That becomes no fault, which means you can evict, but then you have to provide that assistance and that waiver of the last month's rent. So, what's our takeaway from this? Landlords cannot evict tenants at will, even upon the expiration of a lease, like we just talked about. Nor can they increase rents beyond certain limitations. Tenants have a right to enforce the law through the rent board or in court. So that comes back to it. What happens if you are a landlord and you violate that? They can take you to court. They can go get a judgment against you as a landlord for having violated this law. So again, really good idea to consult an attorney or a property manager, because this is all pretty thorny. Yes?
AB 1482, or the rental assistance, the no-fault eviction, is that expiring at the end of the year?
No.
There's a certain amount of money that the landlord has to pay the tenant if They've been there for over 2 years.
Yes.
And it's a no-fault eviction.
Yes.
I thought there was that specific amount or that specific rule was expiring, or it just hasn't been extended yet.
I am not aware of that, because what I understood is that was in place until 2030, and that it all will sunset at the same time.
Okay.
So I'm not aware of anything like that. Yes.
On your list of no fault, did one of them cover that they just want to sell the property?
Yes. Well, only if they are withdrawing it from the rental market. If they're going to sell it to someone who is going to continue renting it, not necessarily. So.
So how do you know that?
Well, it depends on what, sometimes that's communicated during a sale, sometimes it's not. But if you have a buyer who's buying a property that's subject to a lease. Now remember though, not every property like that is covered. In fact, let's go back to the beginning of all residential real properties. Again, if it's a single family home that's being sold, and it's not, if it's owned just by the people or by their own trust, not a special real estate trust or a corporation or an LLC, and the lease covered that, then this doesn't even apply. So those restrictions wouldn't apply. Now, let's say for some reason, maybe they didn't give the notice in the lease, or it does apply. If you're selling subject to a lease, that lease continues whether or not you sell the property. So just by virtue of the person taking over ownership doesn't destroy the lease or the tenant's right to stay on the property. That's what they call runs with the land. So in that case, the buyer needs to understand whether or not these restrictions are going to apply and whether or not they have to be governed by them if eventually they want to pull the house from the rental market.
And what if there's no lease in place, just a verbal agreement?
Then there's no exception then, because again, landlord has to notify the tenant in writing that the tenancy is not subject to the just cause requirements. So if there's no lease there, but they're staying there, kind of what we would call a tenancy in sufferance, they still have the rights of a tenant. And in order to evict them, you have to go get an unlawful detainer. You have to go get an unlawful detainer process and through the courts and get a judgment. But you're going to probably have to go through, the statute, because unless an exception applies, it applies.
Eric,
Yes.
on the rent control, the 5% increase up to 10%. So if somebody is month to month, there is no lease, they've lived in there for many years, but it's a single family owned by an individual, those increases still apply, right?
Yes.
The limitation of the increases apply.
Correct. Yes. You have a question?
So there's a lease in place, but say their contract is over by December the 31st. And I tell them, I want to move in one of my grandkids into this rental property, so you're going to have to leave by December 31st. Do I need to provide proof that my grandkids are moving in?
Not really. That's the kind of thing that would get challenged later.
Okay.
If they found out somehow that your grandkids didn't move in, then there would be some liability. But I think you'd be covered
Okay.
if
I'll
you're
just tell 'em
because
why I
you're
changed
pulling
my
it
mind.
off. You're pulling it off the rental market, like here.
Okay.
So.
Perfect. Thank you.
Sure. Okay. So I have a little bit of time. So what I was going to talk about, and if you have other questions on that, I'm happy to answer them. But let me jump into another topic that I thought might be interesting. And Martha said, yeah, let's do that. And it's called partition actions. And so let's say that you have a brother and a sister who basically take the property. Let's say mom and dad had a living trust in which they say we're leaving the property 50-50 to brother and sister. So parents pass away, per the terms of the trust, title gets transferred to brother and sister. Brother says, great, I want to sell the house. Sister says, no, I want to move in. I don't have any interest in selling the house. They're 50-50. Nobody can force, in that regard, without the law jumping in, the other to do anything. So then what happens? This comes up a lot because kind of the baby boomer generation's getting a little older, so trusts are coming up, kids are getting things, and a lot of times they don't agree, or somebody will say, I want to sell it now. Oh no, it's a bad market, I want to sell it later. Whatever it is. So what happens at that point? Are they stuck, or is there some kind of recourse? If I'm talking to you, that means there's some kind of recourse, or else I'd just say you're stuck and we move to something else. The recourse is something called a partition action. And these are pretty popular. I went years, didn't have any, and then all of a sudden everybody's coming to me and wanting some kind of partition action. So what happens is one of those parties who is like, look, we're at a stalemate. I don't know what we're going to do. You file a petition with the court. You file a complaint, essentially, with the court, where you kind of have to sue brother or sister or whoever else is the co-owner and say, hey, look, court, we can't decide on what to do. So I want you to partition the property. What does that mean? Partition the property. Let's say you have a vacant lot somewhere. You could actually, the court could say, okay, you know what we're going to do? We're going to draw a line right down the middle. And you get that half, and you get that half. Because it's all kind of the same. It's just property. Now, most of the time, however, almost all the time, it's not just a plain piece of property. Because one thing the law tells us, too, is that when you have property, property is special. Because it has its own unique characteristics. So you can't just say, well, if you lose a piece of property, you just get money. You can actually, real property is one of the few things. You can go to court and say, I'm going to force that other person to do something. Because that property is special, I want that. You can actually enforce a contract in that way, something called specific performance. That's rare. Most of the time, court just says, well, I can just give you money, it's all the same. But not with property. So what the courts will do in a partition action in that case is they will force a sale. Now, when the courts force a sale, it's expensive. Because what does a court do? A court supervises it. They will appoint an agent. They will appoint an accountant. Because you also have situations where almost invariably somebody says, well, okay, I guess I can sell the property, but I've been living here and I built the back fence, or I replaced all the appliances, I put in new tile in the kitchen. I want credit for that. And then the other tenant would say, okay, and you've been living there, and you got the benefit of living there all that time. What's that worth? And so then you basically have the court appoint an accountant to kind of make all the math work. And that would be part of the order. So what I'm telling you is, one, there is a recourse then if you've got people who are stuck in a property and they don't know for sure what to do. The second thing is, what's good about it is that there is no discretion on the part of the court. Because generally, when you file a lawsuit, first of all, people come and they say, can I sue somebody for this? And you say to them, you can sue them. Anybody can sue anybody for anything. There are people who have sued God. There are people who have sued the devil. There are people who sue all sorts of, no, seriously, there are cases out there. It's bizarre. But I say, or they sue for ridiculous reasons. Say you can sue, but you can't win. That's really the question. Is it worth it? Is it worth the time and expense you're going to do? That's a conversation I have with every single client. Is it worth it? But what happens here, but one of the things you talk to a client about when you say, is it worth it, is will you win? This is one of the very, very, very few instances where you know exactly what the court will do. It's like there's no discretion. If somebody comes in, they are half owner, they say, I want the property partitioned, the court has to do it. So the good thing about it is if you know ahead of time what's going to happen, you can try to settle the case. Because because what I'll do whenever I get one of these in, I write a letter. And I say, okay, here's what I want to do. I represent such and such wants to sell the property. This is how it's going to work. And if you go too far on this, the statute actually says the court can award attorney's fees to the party who applies, who goes through it. It's like, you don't want to be responsible for my attorney's fees. How about we do this? How about we, and I will come to you in just a second. How about we do this? We pick a broker to sell the property. And if we can't agree on one, I'll pick a broker, you pick a broker, those two will talk, and they can pick another one. And then we'll have an appraisal done. And I'll pick an appraiser, you pick an appraiser, they can choose one if we can't agree on it. You can set up a whole process and say, look, and let's figure out the accounting. A lot of times when the cases don't settle, it's because they're fighting over the accounting part of it. But almost always, those cases settle. The only one I heard recently that went to trial is Tom Girardi. If you're Real Housewives of Beverly Hills, he's an attorney who, Martha mentioned I went to Loyola Law School. And when I went there were buildings named after him. His office was literally walking distance from the law school. Big personal injury attorney, and they loved Tom Girardi, and he was walking around campus all the time. Come to find out, he was stealing from client trust accounts and doing some really bad and shady things all through this period of time. Well, I talked to an attorney once who was on a case. He said, yeah, I had a partition case go to trial. I said, really? He says, yeah, Tom Girardi. They wouldn't settle. Everything went to trial, and the court had to make some pretty complicated orders. So, but most of the time you can get these cases settled, so all hope is not lost in those situations. So you really just need to find an attorney who can kind of walk you through the process, and if that attorney is ethical, they're going to try to settle the case early, rather than say, let's blast off with a complaint. No, the idea is like, look, let's see what we can do and save everybody some money on the outset. So that's a little bit about partition actions. I do still have some time, and you had a question.
Two.
Okay.
Pertaining to living trust, you mentioned if you leave the trust 50-50 for, both my kids, but I like one better. But I leave one as the executor, then he has a right to say what's gonna happen with that property without him challenging, this is what I want. Since he's the executor, he's the one that's gonna say, this is what's gonna happen, right?
Really good question. And no, not right, actually. So, first of all, when you are, I handle trust litigation. I do not actually write trusts, but I can tell you the kind of things that people fight about. And the one thing, and you have the right idea, which is, because what you have when you form a trust, the person who creates the trust, generally the way they set up the trust is like, okay, the trust is for me, or the trust is for us if it's husband and wife, and we're going to live on it. And then if one of us, let's say a husband and wife, most of the time, and if they'll say if husband dies, wife gets everything, and then when wife dies, we're going to do these things, and the trust will say what these things they're going to do. Sometimes they separate it out as far as, well, this is their share of the community property and whatnot, but let's keep it simple. So once everybody, the settlors die, they are the original trustees. They'll be co-trustees, okay? When they both die, who becomes the trustee? When you say executor, that's kind of a will term. So when we've got a trust, it'll be the successor trustee. And if you are writing a trust, please do not do this one thing I'm going to tell you. That sounds like one of those websites. It's like, they're saying one thing not to do, and then you have to read through a bunch of clickbait to get to it. The one thing you do not make more than one successor trustee. Don't do it. I know you love your kids the same. You really do. Don't do it, because they will then fight over how to manage this thing. Make one of them the trustee, the successor trustee, so that there's no fighting later. That's when it gets ugly. I have a couple of cases right now that are that way, and people are banging their heads against the wall. Why did they do this to us? So that's the one thing you can do to really help your kids. The second thing is the trustee who then takes over owes fiduciary duties. They are in a position of trust, meaning that I, as a beneficiary under the trust, can expect that trustee is not going to put him or herself in a better position than me because they had the good luck to be the trustee. And really, in a sense, if you look at it that way, because then the trustee has to do what is in the trust. They do not have discretion to figure out, well, maybe I'm going to do this, maybe I'm going to do that. They may have some discretion. Let's say that there's a property and they want to sell it. Yeah, maybe they can pick the broker. Maybe they can invest it. Maybe they can decide to sell, not sell. It depends on what the trust says. But whatever decision the trustee makes, they owe a duty. And if they violate that duty, then they get sued for breach of fiduciary duty. So yeah, being a trustee may be great shakes. Maybe it's not, because you then owe a duty to somebody else. But what's very important in drafting a trust is to be very specific as to what's going to happen. You can leave property to more than one person. You can do whatever you want. It's up to you. You could leave it all to the benefit of your dog. People do that. We have a good friend who's a trust attorney. Be happy to write a trust for you that's going to leave everything to your pet. Or you can leave it to charity. Do whatever you want. But you got to be really specific, because you don't want to put whoever your trustee, successor trustee will be, in a position where that person's got to figure it out and where they're going to fight about it. So the more specific you can be, the better. But no, trustees do not have unlimited ability. Successor trustees don't have unlimited ability to do whatever they want.
Okay.
That's the long answer to a short question, but I'm a lawyer, I get paid by the word.
I heard that since I'm shopping at Nordstrom's every weekend and I'm charging up my cards, blah, 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 that if you have a trust versus a will, that your children will not be financially responsible if I decease with my bills. Is that true?
Largely, yes.
Okay.
Largely, yes. However, I'm going to put a big caveat on that. That's not the work I do.
Okay.
I'm brought in. There are 3 different types of trust lawyers. This isn't a joke. It's not.
Okay.
It really is. There's 3 different types. There's the kinds that write them. There are the types who administer them. And then there are the types that litigate over them. If people are fighting, they go hire a lawyer. That's me. I'm the third part. I don't write the trusts, nor do I help the trustees administer the trust. But there are lawyers out there who do that specific thing.
Thank you.
Sure. Martha?
My question, which is the probate. So the court assigned the administrator, and she has to sell the property because, you know, no, it's not getting paid, the taxes are, you know, it's the owner's not there anymore. But the tenant, or the person that's living in the property, like what you said, is staying there and for free. How do you get that person out so she can sell the property?
Well, and my answer to you was kind of a mealy, squibbly attorney answer, which is, I don't know, because I don't know enough facts. But I can tell you specifically, it depends on what the status of title is. Does somebody actually own it now, or is it still going through the probate case? If somebody actually does own it, you have to get real fundamental to figure out what everybody's rights are. Does somebody actually own it? Okay, it's been through the probate process, the sale has taken place, or the transfer has taken place. I can go pull title through Veronica, and it'll show me who owns the property. Okay, great. Then, okay, what rights does this person who is living on the property have? Are they a tenant? No, they're an heir. Okay, well, they were an heir under what? Did the court already adjudicate that person's rights? And then it comes down to simply, can I go file an unlawful detainer action against them? If they're there when they're not supposed to be because I have title, court says I have title, I can do what I want with my property. This joker's still living there. I don't want this joker there. So I'm going to file a case to get him kicked out. So it all depends. And that's the kind of thing you just take your pile of documents and orders and take a case number to your lawyer, drop it on the desk of him or her, and say, help me figure this out. And that's what we do.
Okay.
Other questions? How am I doing? We still got a little bit of time, or are we? Yes.
So you know how, like, for example, in Santa Monica, you always hear the stories of renters, you know, I'm paying like $1,000 a month, this and that.
Yeah, rent control, right.
And you know, sometimes like landlords would get creative and try to just evict the tenant so they could get a new tenant at a higher rate, but that's like illegal. Is there anything in like California state law that would prevent you from evicting a tenant for that, just to have a new tenant at a higher rate?
All sorts of things, both in state law and and in the city of Santa Monica. So when you have rent control jurisdictions like that, most of the time the cities have their own restrictions on evictions and trying to avoid that very thing. Or, as opposed to 1482, when I said that you could set your initial rent for whatever you want, in that case they have a restriction on the initial, the initial rent. So that it's not something where as long as, hey, if I get this person out, I can charge the next person $1,000 more. Not under Santa Monica law, probably in that respect. And Santa Monica is very restrictive. Other questions? Yes, ma'am.
So they have a specific situation, is it best just to set up an appointment to meet with you, or do you just do a consultation over the phone, or what are the steps when you actually?
Yeah, if you have a situation, I generally like to know up front. It's like, okay, what's it about? And I'll do like an initial read. I worked at another office for 22 years. I just started at a new office, a Schulman Bastion office. By the way, that's my contact information if you need it. If you didn't get one of my cards, there are some floating around. They don't want me to do free consultations. So I generally don't. But what I will do is make sure that if I'm going to consult with somebody, it's going to be meaningful. That this is something I do. For example, if somebody comes in with a trust administration thing, I'll say, nope, that's not me. I know a good person where I can send you. But if it is for me, then at least I can have an idea so that if we're going to do a consultation, then it's going to be something that'll be meaningful and that you'll actually have some usable information coming from it. But as Martha and Veronica know, I talk to a lot of folks that, for free about a lot of things, probably more than I should. But I figure it's a good way to show people that old lawyers aren't beasts. Other questions, or are we good to go?
I think we're.
What? Got one more?
Normal month to month, and you want to notify somebody that you would like them to leave, is it still a 60-day notice, or?
If it depends on whether the criteria are met to make it an exception. If it's just a house that, for example, if you were the landlord and it's just your investment house, and you had a lease that covered and said, hey, we're not covered by 1482, or it all depends on whether everything is satisfied. And that's why you go to a lawyer, and the lawyer can kind of run through the provisions to find out whether or not it's covered by the eviction restrictions or not. So in that situation, probably not, but maybe. I don't know. I'd have to look at it specifically. Yes.
One more question to something I asked before about there's no lease involved, but you have tenants that are there and they're paying a little amount for rent. Can you just give them the notice now that explains the rent control thing? Can you just
Oh, sure. Yeah, you can do that now. Yeah, you can. That way, you then have them covered.
Right,
Yeah, going forward. So no, that makes a lot of sense. What you found, by the way, the one thing I didn't cover is in a lot of situations where AB 1482 applied, or particularly during the pandemic, and people still need to get people out, cash for keys, which is, I will give you $2,000, tenant, if I get this property by X date, broom clean. Everything is moved out. It's not like you've scrubbed the walls, but basically broom clean, I'll give you X amount of money. And those negotiations took place all the time. It's like, because even if they go to court, landlords are going to have to pay lawyers, going to have to pay court costs. It's expensive. So a lot of times, some of the way you get around some of this stuff, good old-fashioned green. Give it to, say, I'll pay you X if we just get around the situation, and sometimes tenants are happy to take it. Other times, tenants talk to other tenants, and they get really smart. And they figure out what they can do and what they can get away with and what they can't. Yes?
If our clients do the cash for keys, is there some document particular that we should have?
Oh yeah, yeah. You want to have them sign that,
Okay.
and you have a lawyer draft it up for you to say, okay, I agree to vacate the property by X day. I am accepting this in for consideration for doing that. I agree to have it in this condition, and then if they renege on that contract, then you can use that to evict them and to sue them for a breach. But you're also not going to pay them until they actually do it. That's the other thing. You don't pay them up front. You pay them when they hand you the keys and you look at the property, everything's clean. Okay, here's your money. Okay, yeah, there's a lot. There's the only limit on the kinds of cases that come across my desk are but limited by the imagination of human beings. You would not believe what people do for each other, what people do to each other. And we get all of it. So any way I can help, I'm happy to do so. Thank you very much. Really appreciate your time.
Okay, so we're done. Thank you for attending. Last thing I wanted to share. So tomorrow's broker preview is 8353 Edmaru Avenue in Whittier. And and it starts at 10. So if you guys want to go, that's the address. If you need it, let me know and I can text it to you. Okay, so tomorrow at 10. Thank you.